Good morning and very welcome to the webinar on blockchain technology and smart contracts. We have quite an audience. I was told by the Secretariat that more than 240 participants will take part. And it is a fascinating topic and it's a very important topic. We will discuss various aspects relating to the project as such, but also surrounding the project. In this project, we aim to give guidance, particularly to the judiciary, on if a case comes up regarding blockchain technology and smart contracts, how that case could be approached. So it's not binding, it is guiding. We call them guiding principles, and focusing on blockchain technology generally and smart contracts, although we are considering perhaps to split up the project and have first a report on blockchain and then on smart contracts, but that still is under discussion. The two are, of course, closely connected. I don't think that I should explain what blockchain technology is about. I assume that when you take part in this seminar, you at least understand the basics. It is about a distributed ledger, that we talk about public blockchains, for instance, like Bitcoin, but also other types of blockchains, about smart contracts as self-executing programs, and what the legal aspects are. It's really my pleasure to chair this panel with such excellent speakers. The first speaker will be, and I will introduce them all briefly and then give the floor, will be Dirk Staudemeyer, Head of Unit for Contract Law of DG Justice and Consumers at the European Commission. Then we will have Stefan Karpicek, co-founder of Etherisk, a startup building decentralized insurance applications, followed by Martin Hansel, recently appointed as co-reporter for this project, and he is an associate at Ernst & Young Law and wrote a PhD on blockchain and smart contracts. And then my co-reporter, Juliette Sénéchal, a professor of private law at the University of Lille. And then finally, to introduce myself as chair, I chair this project. I'm also a co-reporter, and I'm a professor of civil law and European private law at Maastricht University. Well, without further ado, I think we should start with the presentations. And it's my pleasure to first hand over to Dirk Staudemeyer.
Oh, sorry. Now I was on mute. Sorry. Good morning, everybody. It's a pleasure to be here, and thanks to the Eli for the invitation, and thanks for your kind words of introduction. Now, my topic today is announced as smart contracts in the data economy. Now, I understand this topic is giving a bit the broader picture and the political context to the Eli work on smart contracts. Now, as you perhaps may have known, the von der Leyen Commission, since it started, had basically two main strands of work, and they are called the twin transitions, the digital and the green transition. And because of the corona crisis, the recovery from the pandemic has been added to one of the main things. But I would like to focus a little bit on the twin transition. And the main tool for the transition of our economy and our society to a digital economy and digital society is the data economy. Especially the increase of the Internet of Things and the datafication of all kinds of industrial process has led to a huge amount of data, a phenomenon which is normally called big data and described by the three V's. So big volume or high volume, high velocity, and high variety. Just to give you a few examples to explain a little bit the development or to put this into the context. And for my first example, I go back to 2013, which is the stone age of the digital economy. At that time, Google processed in one day 24 petabytes of data. Now, a petabyte is a 1 with 16 zeros of bytes, basically. So that's already quite a lot, and it corresponded to several thousand times of the entire contents of the Congressional Library of Congress in the US. And in the same year, the amount of globally saved data was estimated as 1,200 exabytes. Now, an exabyte is a 10 with 18 zeros, basically. Now that, if you have put that in on CD-ROMs, you would have achieved 5 towers from the Earth to the moon. But that was in 2013. So that's Stone Age for the data economy. What was so remarkable in the last years was the increase of the data saved and processed. There are estimates that alone in 2016 and 2017, 90% of all worldwide available data was created. And the Commission mentions estimates in the data strategy, which was adopted this year, but the amount of worldwide produced data will go from 2018, 33 zettabytes. Zettabyte is basically a 10 with 21 zeros to 175 zettabytes in the year of 2025. Now, these are figures. And just to explain a little bit the increase, but what is behind it is basically that if you like the books of Professor Harari, he said in his book about the 21 lessons for the 21st century that data will become one of the normal production factors besides and it will change. It will no longer be real estate, machines, and human labor. It will be first and foremost data. So the Commission therefore also thinks that data is the blood in the veins of the data economy. Now, if data is the blood in the veins of the digital economy, and perhaps AI is the refinery, then the blockchains can become the pipelines. Through which data are transported safely. And that's the development we are speaking about. And it's important to see that the aim is to promote this development because of the economic and societal benefits it has. But at the same time, one should also safeguard fundamental values of our economy and our legal order. And therefore, basically, we look now at data economy in more detail in the data strategy, which was adopted, and in the Europe's Moment communication, which was also adopted, both of them this year. And the data strategy speaks about blockchain in the context of data management. It sees blockchain as a possibility to manage data flows and usage while empowering individuals to exercise their rights. So basically, the idea is that the blockchain allows individuals to have the tools and the means to decide at a granular level what is done with their data. There are different tools. These tools include consent management tools, personal information management apps, and others, but also fully decentralized solutions building on the blockchain. While all of these tools are still in their infancy, they have significant potential and they need, so the Commission, a supportive environment. And it underlines, therefore, that basically new technologies like the blockchain offer a possibility to give both individuals and companies the possibility to manage data flows and usage based on, and that's very important, free individual choice and self-determination. Now, in order to do this, the political aim is to further support individuals to enforce their rights in relation to the data they generate. And they can be therefore empowered through tools which the blockchain offers, and in something which could be called a personal data space. Now, this is one objective. The other one came with the recovery, and that is explained in the Europe's Moment communication, where the Commission very much tries to find ways and means how to help the European economy to recover. And one important actor, SMEs and startups. And basically the idea here also is to make it easier for companies, especially SMEs, to use digital tools and to reduce red tape through digital solutions, for example, in the area of contracts. And one of these tools could be digital contracts. Now I realize my time races, so I will try to be faster for the rest I wanted to say. So just to say that also the European Parliament prepares an own initiative legislative resolution and which is about civil and commercial rules for the Digital Services Act, but here also speaks about blockchain and in particular smart contracts. And if this resolution will be adopted in October next month, then it will ask the Commission to assess the development and the use of blockchain, in particular smart contracts, and to provide guidance to ensure legal certainty for businesses and consumers, and to make proposals for an appropriate legal framework. At the same time, the Parliament has also suggested a pilot project and given some money. This is likely to be adopted also towards the end of the year, and the Commission will have some money available through this pilot project, but also through the Digital Europe program, a major program adopted under the multi-annual financial framework, which will propel the digital transition. And a major part of this will also deal with the blockchain and smart contracts. Now, very briefly, how can smart contracts deliver on these objectives which I explained? Basically, there are two ways. The first way, how to give this, sorry, it's not about smart contracts, it's about two ways how to give the individuals, I misspoke, give the individuals the way to decide at a granular level what is done with their data. One way is the traditional way, if I may call it that way, that is basically to use an intermediary. That could be a for-profit intermediary or non-for-profit intermediary. It could be a data broker, or it could be a non-for-profit association who helps data subjects to manage their data. That is clearly one way which is pursued. But the other possibility is to could use technology, and that is smart contracts, to give individuals the chance to manage their data themselves without an intermediary. And smart contracts would allow every individual to decide in advance what will be done with the data, who has access to the data, for which time, for which purpose, and possibly what could I get out of this for myself in terms of a kind of economic benefit. And this is where the big potential for smart contracts lies. Now, my time is over, and I would like to, we were asked to respect our time, so let me conclude basically to say that the digitalization is one of the fundamental trends of our century, and it will change our economy and our society in a way which is only comparable to the Industrial Revolution. Now, in order to achieve these positive effects for our economy and society, this process of digitalization may need a framework. And the law, among others the private law, provides some tools for this framework. So basically to facilitate on one hand the deployment of smart contracts, and on the other hand to give individuals the tools and means to decide what is done with their data, smart contracts could be one of those tools. Therefore, we're very much looking forward to the results of the ELI project, and I personally am very much looking forward to our discussion. Thank you very much.
Thank you very much, Dirk. That was very, very illuminating, brief, but very clear. It's very interesting to see that the Commission is taking initiatives, that the Parliament is taking initiatives, so that it's basically EU broad, EU-wide, that this interest in blockchain and smart contracts exists, and that it is realized how enormously important these developments are for the development of the European economy, but also what European citizens can do with the data that are assembled about them, that are being created. The next speaker will be Stefan, who will approach the problems that the working group is dealing with from the perspective of a non-lawyer. Stefan and I had some very interesting discussions already, and he's a bit worried perhaps that speaking to a group of non-lawyers might be difficult, but I'm sure that Stefan's presentation will be illuminating. So the floor is yours, Stefan.
Thank you so much. Yes, thanks for having me. I feel very honored to speak to you, and you already mentioned it. I have no legal background, I have a technical background, and I'm a long-term practitioner, and you could say a blockchain enthusiast, a heavy user of blockchain technology for many years now. I have also started 2 blockchain startups. One was dealing with educating managers and executives about blockchain technology, and the other one was about building decentralized insurance applications. And of course, along that way, we encountered many legal issues, yeah, but as I said, I have no formal legal background, and so I also find it kind of funny that according to the agenda, I, as a non-legal person, should give a try to answer the really tricky legal questions here. Yeah? So, but I will try to do my best and provide some information from a practitioner's point of view, and in the hope that this is helpful. So the first question, which law applies to a transaction on a blockchain? Yes, that's an interesting question, and it's not easy to answer. First of all, I want to be clear on the terminology used and come with some definitions. I think it's extremely important in this very nascent field of technology that we are clear on the language used, and that there is a certain agreement on what we mean by certain terms. So I will refer to the upcoming publication of the ELI working group on that matter, and that also references some ISO standards about the vocabulary used. And so, and let me also say, it's important to know and understand what type of blockchain we are talking about. There are different kinds of blockchains. And in the following, and for the scope of this discussion, I would like to constrain myself and also maybe parts of the rest of the discussion to public and permissionless blockchains. I think that's the most interesting aspect about this technology, that it gives rise to new kinds of organization forms, new systems, that have some very interesting properties also from a legal perspective. So when we talk about blockchain, I understand that we are talking about public and permissionless blockchains. Now, what does this mean? Anyone is free to participate in such a blockchain system. It does not need any authorization of any kind to perform any activity on such a blockchain. And what is a transaction on such a blockchain? It is a unit of information, a piece of information that is that makes up the blockchain. So a blockchain consists of a set of blocks, a sequence of blocks, and each block contains 0 or more transactions. And it's important to, so the ISO definition calls a transaction a unit of a work process that results in a state change. So it requires a sequence of actions until a transaction is included in a blockchain. And I think it's important to look at who are the actors behind the transaction. Yeah. So in order for a transaction to be included in a block, it needs to be prepared. Someone or something needs to prepare the transaction, decide from which address to which address shall something be sent, a value, some technical parameters. And then most importantly, and I also think from a legal perspective, most importantly, a transaction needs to be signed with a private key, with a digital signature, a cryptographic signature. And then it needs to be broadcasted to the network. And in the network, many nodes will compete to validate this transaction and then to finally mine this transaction, the so-called miners, which have a strong economic incentive to do that. So they are getting paid for mining those transactions. And then after some time, after time passes, a transaction can be considered confirmed. And that's that gives a few interesting properties to this transaction. So first, it becomes immutable. It becomes impossible to change a transaction after the transaction has been executed and mined. And this means you have very strong cryptographic and technical guarantees when it comes to the information contained in a transaction. And then depending on the type of transactions, we also have different types of transactions. Some transfer values, assets, cryptographic assets, so-called tokens, and some transfer information, some transfer both. So depending on the type of transaction, we also have to have different options about what kind of law can apply. Yeah? So when we consider cryptographic tokens property, of course, property laws can apply. In some cases, maybe contract laws. But the question which law applies to a transaction on a blockchain is also, from a practitioner's perspective, not often relevant, right? I understand that for this audience, and you are all legal experts, this is an interesting question, but you have to admit that a public blockchain like Ethereum or Bitcoin, there are hundreds of thousands of transactions taking place every day, and in Ethereum just passed 1 million transactions per day recently. For most of those transactions, you don't have the information to even find out what law applies. You need to have additional information, additional context, and you can only attribute a transaction to a natural person or a legal entity when you have such additional information. And this is most often only the case when the parties agree. So when the parties share that information willingly. You know? And so that's an interesting question, and I understand that the most interesting question from a legal perspective is, yeah, well, who can you sue if you are not satisfied, or if you think your interests are not well covered by a certain transaction. And as I said, first you need to find out who is behind the transactions, and if you can do that, then you need to look at what jurisdiction applies, what's the geographic region of that person or that legal entity that was responsible for this transaction. And that's not so easy. Yeah? And I think the approach taken by the working group to work with functional equivalence is a very good one. But it also has its limits. Yeah? And I think it's important to understand that we are dealing with a new kind of technology. The old concepts must not necessarily apply in the same form. Just to give you one small example, when we're talking about property, in the physical world, we have a pretty good understanding of what this concept entails. In the digital world, we are developing that understanding, but in the cryptographic world and in the blockchain world, whoever has access to a private key has access and full control over the related cryptographic assets. And to think of this ownership versus access to control access, this has some interesting consequences when you look at it through the lens of property law. And there are also some interesting proposals from law firms, from this group here, how to deal with that. Do I have 1 more minute? Then I would touch on smart contracts. Smart contracts and of course the relation to contract law is obvious, yeah. But I want to say, and I cannot repeat this often enough, smart contract is a misnomer. I like to say it's neither very smart nor is it a contract in the legal term. It is a piece of software. It is a computer program that is living on a blockchain, in most cases a public blockchain. And people interact, or users or agents or machines interact with such a smart contract using transactions. And as I said, the users don't really care about the legal environment they are operating when they are interacting with a smart contract. It is more that users rely on the cryptographic guarantees, on the technical guarantees, and on the economic incentives of other participants when dealing with smart contracts. And there is not much need to rely on a legal system or even to trust a legal system to cover your interests. And I think that's a very important differentiation to make. And that's also the root of the confusion and the necessary discussions. And I'm looking forward to having some of them with you here. Thank you.
Stefan, thank you very, very much. You made it very clear. Everyone involved in this area knows this, but still, that these technical developments are looked at in a very different way by, let's say, people who work in that area technically, so software developers, those who use blockchain, those who use smart contracts, but at a technical level, and lawyers. That the perspective is different, but in order to give legal replies to the various questions, we need to work together and basically understand one another. Lawyers need to understand the technical side of these developments. They don't have to become programmers themselves, but they need to understand what programming is, how a blockchain works. At the same time, it would be good, and I'm really happy that you show that that is possible, that someone with a purely technical background looks at the law and understands how lawyers think and what the problems are that lawyers are faced with. And what I found also almost reassuring in what you said is that at the end, behind any computer system, any program, there are people. So that at the end, it is about people. You sue in a legal proceedings people, or at least legal persons. You're not suing somewhere where someone in the void. And I think it was really good of you to stress that point as well, that at the end, it always comes back to people. So thank you very, very much. We now turn to Martin. Martin is one of the co-reporters for the project, and Martin will present some aspects of what the project achieved so far, and explain also a little bit about the doubts that we have, questions we ask ourselves. Martin, the floor is yours.
Thank you very much. Yeah, first of all, it was very interesting to hear the different points of view and the different opinions of Dirk Staudenmayer and Stefan Kapiszek. And I would firstly like to talk about our group, our working group, and what we have already talked about in the group, but also then, of course, talk about my experience, maybe in the Q&A session later, my experience as lawyer at EY Law, because as Stefan Kapiszek has just said, lots of companies operating in the legal field, operating in the field of blockchain, have legal questions, and they do not really know how to deal with applicable law, etc. And this is also where we as legal practitioners where we kick in and where we try to help. And this is also one of the aims of our project as working group, that we want to give some guidance for legal practitioners, but also for startups, in order to enhance innovative ideas and business models. So what we basically did within the last couple of months when I also joined the project, is we discussed at first definitions, as Stefan Kapiszek has already outlined, because it is very important to have a common understanding of what we are actually talking about, since it is very new, and since we need to have a common definition, a common understanding of what we are talking about. And based on those common understanding, what we wanted to do is we wanted to draft principles that give some kind of guidance to legal practitioners, to legal literature, etc., where we stand and what we think could apply to blockchain and smart contracts in general. So what we first did is we drafted one principle connected to private international law. You can see it right now on the screen. It says that transactions made on or supported by blockchain are subject to the rules of the law that would apply to functionally equivalent transactions outside the blockchain. This includes all rules of private international law. The mere fact that the blockchain is decentralized and generally distributed and located in different countries does not necessarily constitute an international dimension in the sense of private international law. So why did we talk about this, or why did we even consider this principle, or the need to draft this principle? This is basically because in legal literature, it is sometimes argued that every transaction on a blockchain is in fact an international transaction in the sense of international private law. And this is justified and substantiated with the fact that the nodes on public permissionless blockchains are usually distributed internationally. And so those people are, those people in legal literature argue that because of the fact that the nodes are distributed internationally, every transaction is an international transaction.
Martin, I'm sorry to interrupt.
No, please feel free.
The principles are not on your screen yet.
Oh, sorry. They're not on the screen yet. What?
So your PowerPoint is on screen,
okay.
not the principles.
Okay, so then it's the wrong screen that is shared. Thank you so much.
Okay, I'm sorry to interrupt.
No, please. But just let me check again. Do you see it now or still?
Yes, but with the other slides to the left of it, but the text as such is on screen.
Okay. This shouldn't be the case. Still the same, but I would then just...
Well, what we now see on screen is the principle beginning with the triggering of transactions or of elements of transactions and so on. So I would suggest you just go on.
Okay, yeah, sorry for that, because usually that works with the screen sharing, but not this time, obviously. Okay, but now you should also see the first principle again, just displayed very briefly, that you can read it as well. And so to come back to the reason why we discussed this is that we discussed in our group that only the fact that the nodes are distributed internationally, this should not only be the reason why every transaction on the blockchain should be considered an international transaction. However, I want to clearly state that those principles are still subject to ongoing discussions and may also are also subject to further changes, since they're not the final principles yet. As you have seen on the first slide, they're still draft principles. And maybe also very quick to the second principle that we have already discussed in our group. When we talk about smart contracts, Stefan Kapischek has also just said maybe in this case contract law could apply or it could not apply, and this is also a question that's heavily discussed in legal literature, and this is also something that we discussed in our group. And the draft principle that we have here now is that the triggering of transactions or of elements of transactions performed on a blockchain may amount to offer, acceptance, or any other contractual declaration where such triggering can reasonably be understood as a declaration of will and is attributable to the relevant party. So what do we want to say with this principle? What do we want to express with it? We basically want to stress that whenever, following the functionally equivalent approach, we want to stress that whenever a transaction on a blockchain may amount to some kind of declaration of will, And this would be a declaration of will off-chain. It could also be a declaration of will on-chain. So following this principle, for example, a smart contract could also be a civil law contract could also be a civil law contract. So what we argue is that we have to, especially when for example, a startup runs a new business model, we have to look at each smart contract and each business model at itself in order to analyze whether a smart contract could also be a real smart contract, namely a contract in civil law in the civil law sense, and this would be the case if it expresses some kind of declaration of will. But I think this will be subject to further discussions, and we will have lots of questions and discussions afterwards in the Q&A session. So I would give the floor to Juliette, Dan and Chef, after having me.
Okay, Martin, thank you. What you made clear is that, first of all, when we discussed private international law, Martin, can you stop sharing the screen? Perfect.
Yes,
thank you.
course.
Thank you so much. When we discuss private international law, you have basically a negative and a positive question there. The negative question is, well, when do we not have an international transaction? And then the problem is, well, if nodes are in several countries, does that make the transaction by definition international or not? And if you say no, you still did not give a reply to the question, well, what law then does apply in an international transaction, right? Let's say the first step is negative. We say that particular situation is not international, but then you have a second step saying, well, when the situation is international, what law then does apply? So there were these two aspects. And with regard to the second principle, you explained, well, what is happening at a technical level in a blockchain, as Stefan just explained. How should we look at that from a legal viewpoint? Can it be a legally binding act? Do contracts come into existence in a purely technical way? Do you need an underlying agreement? What is the role of what you are doing off-chain or what is happening on-chain? There are various questions there. So I'm sure we will have quite a lot of further questions about that in the Q&A. So thank you very, very much, Martin, for explaining that briefly and within time. And again, my apologies for interrupting you. Juliette, finally, the floor is yours. You're going to connect what we are doing in the project to future EU, well, legislation in a way, perhaps a regulation regarding digital services. And also Juliette is going to share her screen. And there it is.
Do you see my screen? It's okay?
Yes, I do. Yeah, thank you.
Right. Thank you very much, Chef, for this introduction. So, yes, I will ask some questions, some future questions for the project team. And one important question is the link between blockchain, smart contracts, and the new notion of Digital Services Act. So, and one important question that have to be stressed is, are services proposed via blockchains, autonomous decentralized organization, and smart contract categories of digital services? Can they be seen as digital services of effective empowerment of individuals? The notion of digital service is not an easy notion because this notion appears in several European acts at the moment. For example, in consumer law, you can find the notion of digital service in several new directives. The directive of 27 November 2009 and 19, excuse me, amending the directive on consumer law consumer rights, excuse me. The directive of, and two directives of the 20 May 2019 concerning contract for the supply of digital content and digital services. and also in a directive concerning the sale of goods, because there is a new notion that is goods with digital elements, and within the notion of digital elements you find digital services. So in these three directives, the notion of digital service can be defined like this: a service that allows the consumer to create, process, store, and access to data in digital form, or service that allows the sharing of any or any other transaction with data in digital form uploaded and created by the consumer or other users of this service. We can also find in other acts the notion of digital services. In the directive e-commerce, we don't find the notion of digital service. We find the notion of information society services. And we can find the definition of this services of the information society in a directive of 2015. So it's not exactly, and this definition is the following one: information society service means any service normally provided for remuneration at a distance by electronic means and at the individual of demand of recipient of services. And in fact, this notion of service of the information society is a notion that will evolve in the future because, of course, the European Commission stressed the importance to create new acts concerning digital services. And so we have in the future a Digital Services Act package that will occur, and we can find some presentation of this new package in a combined evaluation roadmap and inception impact assessment of the 2 June 2020. And what is the goal of this Digital Services Act is to clarifying responsibilities for digital services. So there is not at the moment a real definition because it's only an inception impact assessment. So there is not at the moment real definition, but we are obliged to make a link between the information society services of the directive e-commerce and the digital services of the future Digital Services Act package, due to the fact that it's said that this Digital Services Act package is directly linked with the modification of the directive e-commerce. So what is the content of these acts, the Consumer Law Acts and the directive e-commerce and the future acts concerning digital services? In every act you can find some elements that are common: duties to inform, in the future perhaps duty of transparency and reporting. You can find also liability, for example, in case of non-conformity of the services. Sometimes you can find non-liability but under condition in case of illicit content. So you will have linked to this the question of the notice and takedown, the notice and stay down, maybe in the future the question of the curation of content. So you find in all these acts you can find the same type of notion: duty to inform, liability or non-liability under conditions. And if you consider that smart contract, that services proposed via blockchain, smart contract, decentralized autonomous organization are digital services, there is a need to identify a legal entity, a legal person that will implement the duties of information or that can be considered as accountable or liable in order to allow an effective empowerment of individuals via smart contracts and via decentralized autonomous organizations. So a legal entity, it's not easy when you are in front of a blockchain. And if we have to find a legal entities, the answer can't be the same in front of a public blockchain or in front of a consortium and private blockchain. In a public blockchain, but also in a consortium or private blockchain, there are several layers. There is a layer of the decentralized ledger or operating system. And there is also the layer of the smart contract or of the decentralized autonomous organization, which can be seen as a set of smart contracts. So it's in the different kind of blockchain, public blockchain and consortium or private blockchain. But in a public blockchain, it will be difficult to find a legal person who will implement the duties of information or who can be considered as responsible, accountable, liable at the level of the decentralized ledger or operating system. It will be difficult. It will be easier to find this legal person at the level of the smart contract or of the set of smart contract. And it could be very important to find this legal entity at this level, at this layer. And at the moment, we can find from a comparative law, in a comparative law approach, we can find in several countries concerning, for example, the question of initial coins offerings, we can be seen as a set of smart contracts in certain circumstances. So it can be seen as decentralized autonomous organization. So we can find in several acts in several countries the necessity to find a legal entity, so legal duty to identify a legal person before the launch of the initial coin offering. In private or consortium blockchain, the solution can be different because there is a possibility to find legal entity, legal person that will implement the duties of information or that can be considered as accountable or liable in several circumstances. At the two layers, we can find legal entities at the layer of the decentralized ledger, because there are a partnership between legal entities in order to create this ledger or this operating system. And you can find also legal entities at the level of the smart contract or at the level of the decentralized autonomous organization. So that was a question for the project team in the future. So our services proposed by blockchain, autonomous decentralized organization, and smart contract can be seen as digital services with all the new question linked to this. And the other question to the project team, for example, but it's only as a conclusion, what is the impact of the different European approaches concerning the notion of conventional transfer of ownership? So it's launch for the project team. So I thank you very much, and I stop sharing the screen.
Okay, yeah, thank you very much. It is really good also to make clear to people taking part in the webinar what the future EU framework will be when it comes to blockchains and smart contracts, based on the framework that we already have in the area of e-commerce and digital services as such. So thank you very, very much for that. I can say that in the meantime, I've been following the Q&A. Questions are flowing in, not to say flooding, and it's we have about 20 minutes left. So I will pick a few questions from the whole list, and I will follow the order of the speakers, if I may. Dirk, one question to you was, how can future EU initiatives, in fact, make the position of EU citizens stronger in this area? So what is the relationship between the plans which the Commission has, what we see coming from the European Parliament, and in fact empowering European citizens?
Sorry, I had to
That's okay.
unmute my phone. I apologize.
Fine. No problem.
So basically, yes. At the moment, as I said, what we are speaking about are, as a political objective, are to empower individuals to use their rights, and there are different ways. And the Commission is working on all those possibilities, but we are at the very start of the work because the data strategy has just been adopted in early spring this year. And clearly the European Parliament legislative own initiative resolution will give us a further push, basically, into this direction to work on that. Now, if one uses smart contracts, the idea could be to say that, but this, first of all, needs to be found out whether this is technically possible. Probably yes, I would say. Whether this is legally possible, under which requirements, we will need to see. But basically, one needs to look at whether it is possible to use smart contracts where citizens can define in advance to whom they want to give their data and under which conditions. The advantage of this is basically that, first of all, they can thereby enforce their rights. They can make sure that their data are used in a GDPR compliant way, for instance. So that's clearly an advantage, which is very important. The second advantage, which is very important, is that citizens hereby have a way to really, to be less than just, oh, I've given consent to somebody and suddenly I don't know what's happening with my data now after this consent I've given. And it's very difficult to control that, what's happening afterwards. Because only if somebody is very stupid and sends then data, sends me then an advertising offer, and I realize, sorry, but I haven't given consent that this person uses my data. So here, this is a way how we can enforce the citizens can enforce their rights according to the GDPR, but also consumer rights. And second, this is a way how to determine precisely to whom data should be given in a way which they can decide in advance the modalities, to whom, the duration, the purpose, etc. So it gives a lot of empowerment to citizens and establishes them as a data subject much more than it was so far the case. So this is basically the idea of empowering individuals. As I said, how it will be done and whether this requires initiatives of any kind, we are not there yet at all. At the moment, we're really at a very early stage. We will look with a great interest at the results of the ELI project, but this is a process which has been launched with the data strategy a few months ago. Thank you.
Yeah, thank you, Dirk. Stefan, there's lots of questions for you, but one is, well, and it's more of a technical nature, but it might be useful asking it here. If you have, on a public blockchain, if you gain a majority, you can change the transaction. The question is, so how immutable are in fact transactions on a blockchain?
Yes, very good question, and I'm glad that this is brought up here in the Q&A because I was not able, due to the time restrictions, to go into detail before. So we have to be very clear what actually can be changed. Yeah? And there are strong cryptographic, there are strong guarantees, technical guarantees, that a transaction becomes immutable after a certain number of so-called confirmations, that is, blocks which are mined after the block in which the transaction was included. And it becomes exponentially more expensive with each confirmation that is happening. So if you wait for, let's say on the Bitcoin blockchain, for 10 confirmations, 10 blocks being mined after the transaction that you are interested in, you have an almost absolute guarantee that this will not be changed, even if a majority gains control over the Bitcoin network. Yeah, so these 51% attacks that are often cited are a probabilistic attack. That means there are some statistical chances that a transaction could be changed after the fact. Mm-hmm. And the consensus algorithm works with the longest chain. So the traditional so-called Nakamoto consensus relies on the longest chain is considered authoritative for all. So this means that if you really want to change a transaction, you cannot change a transaction any time in the past. You can only change one of the very recent transactions. And in this time, something outside the chain, off-chain, needs to have happened, which provides a certain gain to an attacker. And we've seen such attacks in blockchains which don't have this large community support like Bitcoin or like the Ethereum blockchain. And so if you want to be sure that your transaction stays immutable, you should use a blockchain which is widely used, not one of the smaller blockchains, but one of the larger ones. Then you have much stronger guarantees. And you should wait after the transaction being mined for as many confirmations as your business case, as your use case allows. If you want to be on the safe side, wait for a few dozen confirmations, and then this transaction is de facto immutable. Does this answer the question?
Okay.
I hope so.
Right. Thank you, Stefan. Also from Martin, lots of questions, but one question, Martin, is that if you say that a transaction on a blockchain is a declaration of will, doesn't that then by itself solve the private international law question? Because then you can apply more traditional private international law rules. So what is so new then about blockchain?
It's a very good question. If you say it is a declaration of will, there is actually, okay, let me rephrase, let me start once again, because actually, when we talk about smart contract and when in the legal sense, as we understand it, when we talk about the different transactions that may result in a civil law, in a contract in a sense of civil law, and if we examine and analyze a transaction to find that it is a declaration of will, then we think that, or we argue that civil law applies, and therefore it's not that different to usual contract law, and therefore usual contract law can apply. And we can also, for example, define a law that should apply, and therefore also have some kind of choice of law in a smart contract incorporated. So this is it is actually, in that case, if you put it that way, it's not that new, and the existing legal framework is applicable to smart contracts when we, in the case that those smart contracts could be contracts in a civil law sense. Yes, Stefan Kapischek tries to raise his hand.
Stefan?
May I add to this? I think it's important, and what is really new about blockchain transactions is that the declaration of your will in a binding manner and the execution of the whole transaction happens at the same time, right? So by signing a transaction, I declare my will to transact with or to interact, for example, with a smart contract system. I sign this transaction, I broadcast this transaction, and from that point on, everything else is deterministic. And this means nobody can reverse that action, and it's very clear what will happen. And then the execution of the contract, or let's say that the finalization, the final settlement of the contract is in an atomic way bound to this first declaration of will.
Exactly.
Does it make sense?
Yeah, the execution, absolutely. And the execution of the smart contract is therefore determined and therefore also fixed. But however, when we talk about from a legal perspective, analyze whether a transaction is a declaration of will or not, we still have to look at, for example, the person, as you mentioned before, that there are persons behind these transactions. We have to look at what they wanted to do and whether this transaction should be a declaration of will, yes or no. And therefore we have to apply basic civil law and traditional civil law, and this also could apply in these scenarios on transactions on the blockchain. So in that case, we have traditional civil law system that may also apply to some transactions made on the blockchain. So basically, our finding is that we still operate within the legal framework.
Okay, thank you, Martin. Juliette, there is a clarifying question to you. You also have several questions, but one is clarifying, and that is what I would like to ask you. Now the question is, the impact assessment equates the notion of digital service directly with information society service. But there are also different definitions that you can find in EU law. So the question essentially is, what do you see is the relationship, let's say terminologically, but also as a concept, as a notion, between information society service as a concept and digital service? How do you see the two connected, not connected? How do you see that?
Thank you very much, Chef, for this question. In fact, we have to have in mind that the notion of digital information service is a notion of that are 20 years old, and the notion of digital services is a new notion linked to the new technologies that are at the moment implemented by economic operators, sometimes centralized or sometimes decentralized. And we need to, of course, make the link between the notion of information society service and the notion of digital service, but we need also to find a new notion of digital service which is in line with the new technologies that are at the moment implemented by economic operators. So there is of course I will say this in French, in sororité. These two notions are sisters, but they are not necessarily completely the same. And what is really, 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 really important for the Digital Services Act is to have a clear vision of what we want to put in this notion of digital services, because it appears in several acts at the moment. It will appear in new acts, and we have to be coherent in all these acts to be really clear of what is the notion of digital services if we want to have a coherent regulation at the European level.
Okay, thank you. There is another question to you, Juliette. I will now turn around, but now start with you about the DAO. If you say that the DAO is a partnership, then why not apply partnership law? Basically, it's the same type of question asked to Martin. Once when you say it's a declaration of will, well, you know, what's new about blockchain? So the question to you is, what's new about the DAO?
I didn't say that the decentralized autonomous organization is a partnership. I say that the consortium blockchain is based on a partnership. between several economic actors. The DRO is different. The DRO is a set of smart contracts and nothing else. The smart contract may be a contract or not. It depends from a legal point of view. The decentralized autonomous organization, the DRO, is a set of smart contracts, but often this set of smart contract is implemented by a legal person, legal entities.
Right. Okay. Thank you. There is a question to all, but I'm going to ask it to Martin. So Martin, the burden is on your shoulders. If something goes wrong on a public blockchain and you want to sue, and you're also a practitioner, how would you do that?
Very tricky question indeed. Yeah. Yeah. If something goes wrong and you want to sue, you have the first problem is was already mentioned by Stefan Kapišek before. We still need to find out who we are suing, because we can only sue a legal or a natural person when we file a claim with the court. So in that case, if, for example, someone came to us and asked us for help, we would try to find out the identity of the sender or the acceptant of the transaction. We would need technological help. Sometimes it can be done with big data analysis. At least we have had some experience with that. It can be traced back to some legal natural person. In that case, then we can try to sue the person behind the transaction, because what we can say is that law applies to this transaction. The question is just, how do we enforce the law that applies to this transaction? So this is the tricky question. This is also more a technical question than a legal question, I think, because the question here, the difficult thing is to find actually the person we are suing, and not really assessing the legal situation, because this is in most cases quite clear.
Okay, thank you. The final question, because time is running out, Stefan, is to you. A question is about, well, what do you call a smart contract, right? Smart contracts as such, from your viewpoint, are pieces of software, if I'm not mistaken.
Yes.
But can you distinguish, if I may put it that way, different degrees, different types of pieces of software, of smart contracts? Some purely technical, some legally relevant, some perhaps mixed. What do you think?
I think, so I'm very clear that a smart contract is not a contract. It is a piece of software. Show me another piece of software that is a contract in the legal sense. Yeah. If you're using software as a normal customer, a citizen that uses software, you have a legal document. These are the terms and conditions under which you use the software. And of course, some law applies here when using software. But the smart contract is such a software piece. And if you have terms and definitions linked to that smart contract, these define the legal environment and the legal frame in which you are operating, and not the software itself.
Right.
So it is a misnomer, I stand behind that opinion. It is not a contract.
No, what I think the term originally was used by Nick Szabo, and even Nick Szabo regrets that he used the term smart contract.
Yes, yes.
Once was in a presentation where they showed tweets from him in which he said, I should never have called that software a smart contract, because, well, what I think he means is lawyers are running away with my word, contract. Anyway, good. We're coming to the close of the webinar. It's close to 1 o'clock. It went incredibly fast. I've been sharing quite a lot of webinars, seminars, and so on, but this one went incredibly fast. Thank you all for keeping to the time schedule, for very informative, very relevant presentations. for your willingness to answer some really complicated questions in a succinct and clear way. It was really a pleasure chairing the webinar. I thank the participants, and I can answer one final question. The question was, can we as ELI fellows somehow be involved in this project? And the answer is yes. We have the members consultative group, and you can become a member of that group, and then you are getting more involved in following the project. So you will be one of the fellows who will be informed first. So it will give you some extra connection with the project. So I would advise you to become a member of that group in case you want to be more closely attached to this particular project, because we do want our fellows to be involved. The more feedback we get, the more response we get to the questions we have, the doubts we might have in this really rapidly developing area, the more response, the more feedback, the better. So with these words, I would like to thank all of you, all speakers again, everyone participating, everyone asking questions. And given the pandemic in which we live, please do all stay safe and stay healthy. Thank you.